Good morning, everyone. Today we are going to discuss a very important topic of criminal procedure, the criminal trial. So prior moving to discuss about the criminal trial, we will discuss about the types of offenses. So there were two types of offenses. One is cognizable offense, another one is non-cognizable offense. So what is cognizable offense? In a cognizable offense, the police officer have the authority to arrest a person without warrant. Okay. In non-cognizable offense, police officer do not have the authority to arrest a person. Okay. So the cognizable offense trial begins with the FIR. After the registration of FIR under section 154, the police officer either have to arrest the person and produce the accused before magistrate within 24 hours under section 57. Okay, after the production of the accused before magistrate, the magistrate if the magistrate thinks that the inquiry will be investigation cannot be completed in 24 hours, then either he will grant him police custody for 15 days maximum period, and either he will grant him judicial custody for 60 days or 90 days. After that, a charge sheet or challan will be produced before the magistrate, which contain all the details of the case. And after the production of challan, the magistrate will take the cognizance. He will apply he will apply his judicial mind in framing of charges. After the framing of charges, there will be two situations. If the accused plead guilty, then conviction will be done unto the accused under section 252 and 253, and if the accused doesn't plead guilty, then the commencement of the trial will begin after the framing of charges. Like that, there should be a prosecution evidence, and after that there will be a statement of accused under section 313 and defense evidence, and then final argument, and then judgment whether it will be a conviction or acquittal. And in non-cognizable offense, what will be the procedure of trial is that there should be a complaint. In non-cognizable offense, prior before a private complaint to a magistrate, there should be a non-cognizable report should be non-cognizable report should be sent to the station in charge, the SHO of that concerned area, and the superintendent of police, SP of that particular district. After the after that, the complaint was produced to the magistrate under section 2D. So if the complaint comes to the magistrate, what he will do, he will have the two stages. Either he will order the police to register a FIR, or he will inquire by himself. Okay, so the inquiry by himself will be done under section 190, and if the magistrate will inquire in cognizance of the offense, then after that examination of witness will be done under section 200, and after examination of witnesses, if there was no sufficient ground, then he can dismiss the complaint also, and if there was sufficient ground, then he can issue a process under which he will summons the petitioners, and he can also conduct a warrant of arrest, proclamation of person who were absconding, attachment of property can be done, and after that he will apply his judicial mind and cognizance. He will frame the charges, and after framing of charges, the prosecution evidence will be done, and the same procedure which we discussed prior. The statement of accused will be done under section 313, defense evidence will be done, final argument will be done, and there will be a judgment. And what we are going to discuss is types of criminal trial and kinds of trial. So there are four kinds of trial. One is session trial, second is warrant trial, summon trial, and summary trial. So how these warrant, summon, and summary trials were different from session trial? Because the session trial is for the sessions court, and warrant, summon, and summary trials were all for the magistrate code. So the session trial was defined under section 225 to 237, and these were for the ADJ's court or sessions court. The warrant trial was defined under section 238 to 250, and that was a magistrate trial done on complaint or police. In this, punishment was more than 2 years. Okay. And then comes to a summon trial. What is summon trial? The summon trials are those trials that are not warrant trial, and there is no need to frame charges under summon trial. Okay, and the punishment for offences should not exceed 2 years of imprisonment. And then comes the summary trial. So summary trial is the fast forwarding trial. We can say also a speedy trial, or here the procedure is very simplified in manner and very simple that everyone can get the justice. Important quote was also come from this trial: justice delayed is justice denied. And accused were here in summary trial, the accused can be discharged by a simple fine also. So these all are the trials. So thank you.